Good afternoon, everyone. This is Christy Schmidt, Director of Marketing and Communications for Farm Credit East. We'll now get started with the webinar. Thanks for joining us today. Just before we get started, a few technology tips to keep in mind while you're viewing today's webinar. All attendees will be muted throughout the presentation. Every once in a while, just be sure to tap your mouse so that your screen doesn't go to sleep. And there will be time for questions and answers at the end of the presentation, but they can be text chatted in at any point during the presentation. You'll see a red arrow in the upper right-hand corner of your screen. Just click to expand the GoToWebinar control panel, and then there'll be a text box there where you can type in your questions and they'll come to us, and we'll ask them of Leah and Chuck at the end of their presentation today. And finally, a recording of today's presentation as well as the presentation materials will be available on farmcrediteast.com/webinars. If you're having any trouble accessing this recording, please feel free to contact me, Christy Schmidt, at 800-562-2235. And now I will pass it over to Tom Cosgrove to get started.
Thank you, Christy, and thanks to everyone for joining us today. I'm Tom Cosgrove, Senior Vice President for Public Affairs and Knowledge Exchange here at Farm Credit East. I'd like to welcome you to today's webinar, What to Do When the Government Shows Up at Your Door. Just to set the stage for today's discussion, government regulation comes into play in a number of ways in our industry, whether it's the pricing of our products, quality standards, grading, as well as environmental and labor rules. And many Farm Credit East webinars have dealt with these subjects, but usually from the standpoint of understanding the underlying policy or regulation and how to comply with them. But today's webinar is really a slightly different take on that, as it really looks at the enforcement of regulations, or at least the initial phases of enforcement. And certainly some farms know this experience firsthand, may have had an I-9 audit, or an OSHA inspection, or certainly if you haven't had one yourself, you may know friends or neighbors who have. And certainly that can be a difficult and stressful situation. So the intent of today's webinar is to provide some guidance on how to handle that situation, really understand what your rights and responsibilities are. And we're fortunate to have with us today two experts from the law firm of Michael Best to provide some insight on the subject. With 220 attorneys nationwide, Michael Best has an active food and agribusiness group with offices and clients across the country. So first, I'd like to introduce Chuck Palmer, who's based in Wisconsin, originally from Montana, and you'll see some of his many accomplishments shown on the screen. But Chuck brings deep experience in this area, having worked on OSHA-related cases for over 25 years, including some of the first actions related to OSHA inspections on dairy farms. And he now works with clients across the country on this subject. He has degrees from the University of Wisconsin and Marquette Law School, so we welcome Chuck. Next we have Leia Zimba, who co-chairs the firm's Agribusiness Food and Beverage Group. A native of Wisconsin, Leia spent 15 years in New York and attended the College of Agriculture at Cornell, as well as Syracuse Law. She's worked for the New York Farm Bureau and the law firm of Nixon Peabody, and has worked with a number of ag clients in New York and across the country. And she still does this now that she's back in Wisconsin, where she and her husband are part of their family's dairy operation. So we're glad to have you with us, Leah. And again, we appreciate you both joining us today, so I'll turn it over to Chuck and Leah for the presentation.
Thank you, Tom, and thank you, Christy. We are very excited to participate in this webinar today with Farm Credit East, and I think it's a great partnership and an opportunity to talk today about government inspections. Hopefully you can see the first slide of our PowerPoint screen. As any good lawyer would do, I have a disclaimer on the first slide.
Leah?
Yes.
You just need to click to share your screen.
Oh, I think we have. We'll just figure that out. Bear with us just a moment.
There you go. Now we can see it.
Okay, perfect. Thank you for bearing with us. I was just saying that I have a disclaimer on the first slide that this is not legal advice, and as any good lawyer, there has to be a disclaimer, right? But Chuck and I are going to walk through with you. This is the agenda that we propose to cover today, and we're going to make sure we leave plenty of room for questions. Chuck and I both work with regulated industry from different perspectives. I in an environmental and food and drug regulatory perspective primarily, and Chuck on OSHA and Department of Labor perspectives. So we're going to talk, we're going to share our expertise in those areas, talk to you a little bit about the government agency's authority in general to inspect, cover things like the Fourth Amendment, talk about some general inspection practices and kind of best practices for how to manage an inspection. And then we're going to walk through, Chuck's going to walk through his expertise on the OSHA inspection matter and kind of walk through step by step in the context of an OSHA inspection. I'll then cover ICE and some Department of Labor matters. And again, we'll leave room for questions. So we all know there's a Fourth Amendment. We all think we know generally what it is. I thought that this would be a good way to start the conversation generally about government inspections and government searches. The Fourth Amendment, this is the exact language. The key that I think is relevant for today's purposes is that every person, including businesses, have a Fourth Amendment right. And it's a right against an unreasonable search and seizure without a warrant. And warrants are only issued upon probable cause. Now, so there are, so the key being there, unreasonable searches and seizures, probable cause, and requiring a warrant. There are significant exceptions to requiring, to needing a warrant to conduct an inspection, and those we're going to cover today as well. The key is that there are ways that an agency could come on your premises without a warrant. The first being consent, and we're going to talk about that next. But this is a summary of businesses' Fourth Amendment rights. So businesses, just like people, do have Fourth Amendment rights. Again, it's prohibiting an unreasonable, warrantless search. This applies to administrative searches as well as criminal searches or criminal investigations, which is when we typically think of the Fourth Amendment rights. And all administrative searches, including searches of any kind, must be carefully limited in time, place, and scope. And we will give examples in the different administrative inspection protocols we talk about that kind of cover what's a reasonable time, place, and scope. The first significant exception, and it's the big one, to requiring a warrant for any governmental official to conduct a search is consent. So if a person consents to a search of the property, that is deemed reasonable, in which case a warrant is not necessary. The consent to a search must be reasonable, so it must be by somebody who has authority to grant permission. It would not, and the way that's looked at is a very fact-specific inquiry about whether or not the person that gave consent was reasonably, determined to be in charge of the premises or the operation and had the authority to consent on behalf of a business. So really, this is somebody in management or an owner that would be able to consent to a search. You would likely challenge whether a consent was valid if it was a child or somebody who maybe didn't have authority to consent. The consent can be revoked at any point in time, and then the search must stop. And I put a bullet in here to remind people that consent can be both, when somebody arrives at your doorstep and wants to conduct an inspection, that's when consent can be given, or it can be given in advance in the form of a permit or a permit term. So consent might be in the form of a permit term. And for example, in the New York State Department of Environmental Conservation permit that an animal, a CAFO, might have in New York, there is a clause in that permit that allows DEC to come onto the premises and conduct an inspection. And there's specific language about the agency's authority to come onto the premises to conduct the inspection. So I want to let people know that consent can be both given at the time that the government official shows up, as well as in a permit term. The other, there are some specific industries that just by their very nature consent to an inspection. Chuck gave me an example this morning about a mining industry. So if you're involved in a mining industry and MSHA, the OSHA equivalent for a mining company, shows up at your door, you don't have the right to request a warrant because you operate a mine, and that's part of what comes with the territory. Chuck will be covering those, those examples later on, but we don't think there's any industries that would likely be on this call that would be, just by their very nature, would need to consent to a warrantless inspection. So we're going to talk just a little bit to set the stage about some general inspection practices. A good inspection starts well in advance of somebody arriving at your doorstep or at your facility, and it really this is where preparation makes all the difference in preparing for an inspection. And Chuck will give you an example in the OSHA context, but the key here is getting the right people at the table in advance to think through what agencies might you be regulated under that might appear at your doorstep. Who are the right people to have around that table to think through how the inspection should go? What are your facility's policies? And that should be thought through in advance. For example, if EPA shows up at your door and they want to start taking photos, do you have a policy regarding photos or samples, that sort of thing? And then record and document preparation and retention. So that's both understanding well in advance what records your facility or your farm is required to keep, how long they must be kept, and also how they practically are kept. Are they electronic? Are they paper? Are they in one location or in several locations? Are they kept with other documents that are not required to be kept? And thinking through kind of your practical document storage and retention protocols is key. Because if an agency shows up and they have the right to certain records, you want to be able to show them those records without giving them access to other parts of your business that might be irrelevant to why they're there. And then we'll talk about actual entry for the inspection, and depending on the agency, this is different. For example, for FDA to enter upon a premises, they have a specific form that they provide, and so every agency has their own process on that. And then the actual inspection or audit and how that happens and how that's best managed, as well as post-inspection protocols. And that's both addressing the items that were identified during the walkthrough and the inspection, what documents were requested, and what the company's next steps should be with regard to follow-up with the agency. I kind of talked a little bit about having your response team at the ready, but the key is to have the right people readily available. And although oftentimes people are accessible by cell phone or other ways of immediate contact, people should think through in advance. There might be a key person for the facility, but what happens if that person is not available or is not able to be reached? Who is the next person in command? And obviously, that person and their team will need to walk through their proper inspection procedures well in advance, and really think through, their operations, the management of how the inspection happens, the appropriate people to have as part of the inspection response team. If OSHA shows up, you might want to make sure you have a health and safety person, if your facility has one, accompany that versus an environmental manager if it's EPA, or somebody else if it's Department of Labor. And so knowing who to contact and how to reach them is key. Also, having the right expert during the walkthrough is critical, so that the OSHA person can look through and see exactly what OSHA might be seeing, and that's a different set of skills than what somebody that works on environmental compliance might be doing and taking dual samples and that sort of thing. So you want to have the right team kind of at the ready. The facility policies in advance, I've already kind of covered this. It's key to know in advance what your company's or your operations policy is going to be with inspections. So is there a written step-by-step approach that that needs to happen, and it should be specific in thinking through if a government official shows up the door and the key person's not there, having the protocol in place to contacting the key representative, having that key representative, come to the location of the agent, having the person who meets the agent tell the agent that they've contacted management, they're getting the appropriate person, and to just be patient, and the process can start. So thinking through in detail in advance of kind of the step-by-step approach for how to respond to an inspection is key. That way, if an inspector shows up on a day where there's other things going on in the operation, you can fall back to that written protocol as to the steps to follow. And we'll talk about the issues of consent and warrants as we go through the agency-specific examples. But understanding the consequences of demanding a warrant versus not is critical. Practically speaking, many times you could demand a warrant, again, a little bit agency specific, but you might be able to technically and legally demand a warrant, but that may not be ultimately the best way to proceed through the inspection depending on the circumstances. So it's a kind of a fact-specific and agency-specific analysis. And we're going to step into some agency-specific examples, and I'll hand it over to Chuck so you can hear from Chuck about OSHA. One thing that I thought I would just cover, again, I do a lot of work on the environmental context, is this quote from Cheryl Burdett of EPA Water Enforcement. This was actually said during a Wisconsin CAFO Owners, Managers, Permit, and Nutrient Management Writers Conference in Green Bay, and just about a year and a half ago, where she was quoted as saying this with regard to inspections. I think the quote speaks for itself, but rest assured, it is not by chance that an agency shows up when the facility is under the worst conditions. For the environmental context, they target wet weather, as Mrs. Burnett just indicated, and they want to see how the facility interacts under the very worst conditions. So that's not by chance, and that also underscores the need to prepare in advance, have a clear protocol of how to manage the inspection during that time frame, and then follow up, which is oftentimes some of the most critical details. So I'm now going to turn it over to Chuck to talk about OSHA inspections.
All right, thanks, Leah. Taking off of what Leah just said about the EPA, OSHA, in the same way, will often show up when you're at your worst. They time it that way. They want to see as much as they can, and typically what they want to see is the operations that might be the most hazardous within your organization. And it's not coincidental that they're doing that as well. And it's been a trend with OSHA over the past 8 years to do that. Right or wrong, or whether you agree or disagree with this approach, statistically, OSHA has resources only to inspect each employer in the United States once every 80 years. So the philosophy, more or less, has been through enforcement, we will achieve a notice to the other employers that you may be next, and that may create a deterrent or an encouragement, deterrent against being unsafe and an encouragement to be safe, by the same way that a police officer who pulls over someone driving down the freeway at in excess of the speed limit will cause everybody else driving along the roadway to see that person shamed alongside the road and slow down. And so this is the approach, and in fact the uniqueness of what's happened more recently is that if a organization gets a fine greater than $40,000 from OSHA, they will send out a news release to 10,000 media outlets about that fine. And there's a quote, or a number of quotes, from the area director of OSHA about that particular business and about how they ignored safety of workers, and it is definitely the shame game that they have engaged in order to get more effective communication to the public about what is expected of businesses. And it does have a significant impact, especially those companies that are in a consumer product business, that they may have effects on their customer relations. When I have a client who gets one of those $40,000 plus citations that results in one of these notices, they'll generally get a call from their banker, from their insurance agent, from other concerned people, board members. It's usually a very stressful day for that CEO and certainly for the person in charge of the safety within the organization. So it's a different set of stakes these days. Now, with respect to OSHA for farm businesses, this is a fairly new experience. The agricultural exemption for farms really kept farms out and agricultural businesses out from the prying eyes of OSHA for many years, and really until about 2011. The growth in the size of agricultural businesses has really brought the focus upon them. If you have less than 10 employees, you were generally not covered by OSHA unless you had a temporary labor camp. In about 2011, there was a fatal accident in Wisconsin. I got called into that accident. An individual had driven a skid steer into a manure lagoon and died as a result of that accident. The employer, in fact, in that case had only 6 employees, but OSHA responded because of the fatality, and they claimed that their authority over that farm was due to the housing being a temporary labor camp, and therefore they could regulate that particular farm. We ultimately resolved those citations effectively, but it led the agency to an emphasis program to focus upon the dairy industry specifically, and I think that that's had some additional spillover into non-dairy agriculture that might not have otherwise been regulated. In other words, the agency realized, hey, wait, there's this whole sector that has changed in its size and therefore is now under our regulatory oversight. So they have begun to develop the same kind of techniques that they did with other industry. The penalties that have been issued in Wisconsin and New York, where the emphasis is going on, have not been huge to the point where these things are going to court. They usually get resolved, but what happens is the agency gets a record with a particular employer, and then if they come back again, then they will, much like a traffic record, you get a warning, and then when you finally get a citation, then the next one's going to be more severe, and they ratchet it up. So the agency has begun to really focus upon agriculture much more. And so this has gotten to the point where employers need to, in the ag industry, start to look at what are the models that other businesses who have been regulated for many years have developed to respond to these agency inspections. So Leah's general commentary about government inspections is exactly on point with respect to how to deal with OSHA. So first of all, much like EPA, OSHA is not going to give you advance notice of an inspection. They bank upon surprise. And that was the design that was built into the Act in 1970 when it was passed, that it's against the law to give advance notice of an inspection. So you're not going to get a call from OSHA saying, hey, we'll be there tomorrow. There are cases where a complaint is questionable that OSHA receives, in which case if they think perhaps it's a disgruntled employee, there's some question as to whether what they're being asked to respond to falls under their authority to regulate, or they question the person giving the complaint, that they may send a fax and make a telephone call asking you to self-inspect and report back to them. And that's sort of a get-out-of-jail-free card that you need to respond very seriously to, put some details together, and communicate back with them, because if you don't, then there will be an inspection, or if you don't respond appropriately, there will be an inspection. Those happen very infrequently, however, and most complaints and other triggering events, such as the fact that you're in an industry that is on an emphasis program, such as dairy industry, you're going to get an inspection rather than advance notice. The dairy industry emphasis program in the state of New York has been extended. They basically are taking those farms that are in the state and randomly selecting for inspection, and there will be no advance notice for those types of inspections. Likewise, a complaint will not generally lead to advance notice, but rather have an inspector show up, knock on your door, and indicate that they're there from the government, show you an identification badge, and tell you they would like to inspect your farm. And then what you do from that moment will decide the process by which this inspection will take place. So setting the stage, always tell employers, you won't win your case during an inspection, but you can lose it. In other words, you're not there to try to talk the inspector into being convinced that you are the greatest employer in the existence of the world, and too many employers try too hard, say too much, and set themselves up for failure. So not necessarily trying to win, but playing defense is important. And the keys to that are preparation, thinking about how the inspection will go, where are the areas that OSHA is going to go, and we've done earlier webinars on the particular subject matter that OSHA will focus upon. And that, in an OSHA case, we refer to that as the dairy dozen. And certainly if you have questions on what is in that dairy dozen, Farm Credit East can be helpful with those materials. So preparation, and then training your personnel how to handle an OSHA inspection when it occurs, and then executing that plan properly. So what to do? So ideally, you'd like to train everyone within the organization on what to do if OSHA shows up, but recognizing the reality of resources available and turnover, you may not be able to train everybody on your procedures. If you get off this webinar today, the one message I'd say is talk this through with your receptionist. There's an office. There's probably somebody that OSHA is going to meet first when they arrive upon your farm or other work area. And does that person know what to do in the event that a government agent shows up? Are they going to say, oh, Joe, the owner, is out back, why don't you go look for him? And send that person and consent to that person basically beginning an inspection while they look for the manager. That's not the way to approach it. So train the receptionist or the first line of contact that the government is likely to have first as soon as you can, because invariably with the number of people on this webinar, somebody's going to have this happen in the next week, and you're going to try to develop a plan that may take you a month to put into place. Talk to the receptionist. What is going to happen if a government agent shows up? What would you do? And maybe you do a Q&A as to how you would respond. Then the answer is we need to know who is going to be the point of contact for government inspections within our organization to contact and be present to decide whether to consent to the inspection or decide whether not to consent to the inspection, and to conduct the inspection with OSHA. It's okay, and many people think, and certainly if you haven't been trained, you think the last thing I want to do is obstruct a government agent. I don't want to make them wait. They'll get mad, and therefore you become overly cooperative. They are used to the fact that they need to wait for the person in charge. Now, there may be cases where if you've had a serious incident, an accident, a fatality, where it's more of an emergency situation, and that wait time needs to be shortened. Generally, I think, though, when some emergency like that happens, you usually have the person who's going to be in charge of handling an inspection on the way or present anyway by the time OSHA gets there. So you got to be a little careful not to obstruct where they're in what I'll call hot pursuit, and this sort of derives out of the law involving police officers. If they're in hot pursuit or they believe a crime has been committed that they need to resolve or address quickly, that may relax the requirement for them to get a search warrant to conduct the inspection, and they may be able to quickly respond if somebody's in danger. And so same kind of concept here. If you've had something severe happen, the delay may need to be shorter. Generally, OSHA compliance officers, or what we call compliance, safety, and health officers, or COSHO, CSHO in the slide, they believe that they only have to wait for an hour. That's kind of the walking around information that they all work with. And many times they'll tell a business owner or representative, you know, I'll wait, but I'm not waiting for more than an hour. As a practical matter, as Leah mentioned, you have a right under the constitutional Fourth Amendment against unreasonable searches and seizures without a warrant. And so you could always demand a warrant. And so sometimes the dialogue, either I'll coach the employer through this conversation or the employer representative through this conversation, or I'll actually pick up the phone and call the area director, say, I've got a compliance officer here. He or she says that he or she has to inspect immediately. My company authorized representative is 2 hours away. They're on the way. We would ask the person to wait, or if you'd like, you can come back tomorrow morning and we will consent to the inspection if you don't want to waste your time waiting, but I have to have my authorized representative present during the inspection. The law allows you the right to an authorized representative, and the law allows you the right to demand a warrant. So the conversation goes something like, I understand that you need to inspect, but we also have a right to require a warrant. We don't like to exercise that right, but my expectation is that if I did exercise that right, it would take 2 to 3 days for you to get a warrant. We're not trying to delay the inspection that long. We need 2 hours because we need our authorized representative there. We will cooperate with you. We will consent, but that's the condition to that consent. And that has always worked in the dialogue with OSHA. They generally, if it's going to be 2 days and you're trying to delay it for a couple days, then they may just go ahead and go to get a warrant. And the consequences of getting a warrant, you know, many employers are, you know, fearful of that because they think, well, OSHA will retaliate. And in fact, you can read things that statistically those who demand warrants get higher penalties than those who don't demand warrants. But I wouldn't necessarily jump to the conclusion that that's a cause and effect. Many times those who demand warrants are companies that also don't have a safety program, they haven't planned for an inspection, and they probably have more problems. So they are likely to get higher citations, not because OSHA retaliated against them for demanding a warrant, but because they were less sophisticated, less safe, and less prepared for an inspection. So you can make the compliance, safety, and health officer in an OSHA case wait for a period of time, and you can engage in negotiations over that delay if they demand to inspect. You need to take control of the inspection from the outset. Don't allow the inspector to, or as I say, the inmate to run the asylum. Take charge if you don't, and you want to manage it not in a aggressive way, but in a polite way that, you know, we've got a lot of operations here that you need to recognize safety concerns we have, production process. So I'd like to, you know, lead you through this inspection, kind of show you what you need to do. And then let's start talking, and this is always a good way to set the tone. If they're there from a perspective of safety, whether it's environmental or FDA or OSHA, you set the tone with how safe you are, that we're so concerned about safety that Mr. Compliance, Safety, and Health Officer or Mr. Or Mrs. FDA, here are our protocols. We'll need to go through those. We'll need to make sure that you understand those and that you comply with our requirements. There will be work going on. We need to not interrupt that work because if we do, that can lead to problems. We have certain safety requirements you'll need to follow, particular boots, how we're going to handle the cleaning of those, eye protection, head protection if that's required, foot protection, steel-toed shoes, and hearing protection, and all the safety protocols that we will be requiring that you want to make sure you're demonstrating to the inspector that you have certain safety protocols or health protocols, and walk through those before anything happens in the commencement of the inspection. Be civil, always be polite, and I make the reference to kindergarten. Everything you learned in kindergarten is all you need to know of how to deal with the OSHA inspector. You're polite, you treat them like you'd like to be treated, understand that they're a human being and that they have emotions as well. And I also talk about kindergarten because I like to set up the inspection approach sort of like you'd see on a Mr. Rogers episode. In Mr. Rogers' Neighborhood, he would take certain experts out to look at a particular operation and ask a lot of questions. And I like to set up an inspection team in which the person who's conducting the inspection is not necessarily the person that knows the most about the operation. They will take the inspector to that person that has the knowledge for the particular topic that's being questioned, but not looking around and saying, I'm going to get the person who knows the most about the operation. Because the danger of having the person that knows the most about the operation is they know so much that when the OSHA inspector asks them a question as they walk around during the inspection, they invariably want to tell the truth and have to answer that question, and they have not prepared to do so. And so a lot goes on in the dialogue that can open up more doors in the inspection process the more knowledgeable the person is about the operation. So if you can pair somebody with OSHA that isn't standing there watching the operations day in and day out, that's a good scenario, because that person can't, when OSHA asks, did you know that this was happening, or did you know that that was happening, or what have you seen happening yesterday, they don't know that answer immediately to have to respond to OSHA. And this becomes important because in many of these government investigation systems, knowledge can become a basis for a heightened enforcement or heightened penalty. You not only did you violate a rule, but you knowingly violated this rule day after day after day. So you minimize the amount of direct knowledge as to what was happening at that particular point in time, being the access OSHA is having to communicate continuously throughout the inspection. So designate somebody. It doesn't have to be the person most knowledgeable. If you're a large enough organization, oftentimes in many manufacturing and other businesses, there will be a safety director, and that safety director isn't on the floor day in and day out managing things. They are correcting anything that they see, and so when they're accompanying the OSHA inspector, they don't have the likelihood to say to the inspector, yeah, I saw that and I ignored it, or implying that by virtue of their answer. So take the person around to look and talk to the persons with expertise, but don't have the person that is most knowledgeable about the operation, daily activities, as the designated person if you can avoid it. Be polite, be firm during the inspection process. At the very beginning, get information and ask questions, and do this throughout. What's the reason for the inspection? What is your intended scope for the inspection? How long does the Compliance, Safety, and Health Officer intend to be there? What does the Compliance, Safety, and Health Officer intend to do? Are they going to take video? Are they going to do air sampling? Are they going to do noise sampling? Are they going to conduct employee interviews? And you keep coming back to this question. I need to plan my day. I need to plan resources available for you so that I know how this is going to go, and so we don't lose anybody because their shift ended. And you enter into a dialogue about what they're planning to do before you get started. And you can do this before the inspection takes place, because part of what you're doing at this point is determining whether or not the compliance officer has a probable cause and is going to conduct a reasonable inspection. Those are the key words in the constitutional Fourth Amendment: probable cause, reasonableness. And so I'm probing as to why are they there, and then what are you intending to do while you're there, so I can compare the scope and reasonableness of the inspection and decide in my mind whether, in fact, it would make any difference if I demanded a warrant. So, for example, OSHA shows up because an employee complained that a particular piece of field equipment does not have a guard on it. And the inspector says, I noticed when I came up that you have a a cheese manufacturing facility here. I'd like to take a look in that as well as long as I'm here. Well, if I don't know that he's there or she's there for a complaint about the guard in the first place, then I don't know what the scope of the inspection should be. I would want that inspection to go out and look at that guard, and you're done with the inspection. But if you consent to go into the cheese plant, then you've consented and you've waived your right to challenge that scope of inspection. You would then want to ask with the compliance, safety, and health officer, I'm trying to understand why you would need to look at the cheese plant when, in fact, this complaint is about field equipment and guarding on that. Well, I've just always wanted to see what a cheese plant looks like. Well, with all due respect, that's not within the scope of what I'm seeing here. I'd have to probably contact my legal counsel if I'm going to consent to that. Is that something that really necessarily has to be done? You're polite, you're firm, you negotiate, and many times if they don't have cause, they may say, well, let me check back with my office and I'll let you know. So you don't expand the inspection beyond the scope, but you need to know what that scope is going to be at the outset in order to make that decision. If the compliance, safety, and health officer won't cooperate, then you may, in that situation, say, I am requiring you to get a warrant if you want to expand. I will consent to the inspection that you have the cause for based upon this complaint. I will not consent to that expansion. What do you want to do? Sometimes that's difficult for folks that are not the owner or not, an executive of the organization. And so in your protocols, one thing you may want to do is create a letter that in your absence as the authorized person, if OSHA is insisting, rather than making that employee who's there in charge in your absence have to get into this sophisticated dialogue about warrants and scope of inspection, you teach them to probe what the basis of the inspection is and then what the intent of the inspector is, and then they contact you and you say, okay, there's a letter that we put in our protocol. Hand that copy of that letter to the inspector, which says, I don't have the authority to grant the inspection or consent to the inspection in the absence of the authorized company representative. So you create a document that they can use in your absence to provide that notice to OSHA. Then when OSHA goes back to or the compliance officer goes back to their boss, and their boss goes to the lawyer for OSHA, and their lawyer contemplates going to a court and asking for a warrant, they've got a document that says, well, he didn't really refuse the inspection. He simply said he couldn't grant the authority. Did you try to talk to the authorized company representative before coming to me to try to get a warrant? Otherwise, the compliance officer comes back to the office and says, they wouldn't let me do the inspection. They told me to go get a warrant, or we got to get a warrant. And there's no further discussion about, well, should we call them again and see if they'll let us come in? If the inspector is insisting upon coming in, this is an example of such a notice. Very simple. There's no intent to deny entry or permit an inspection. We just have to have our authorized representative present. And then that authorized representative can then make the decision about whether to demand a warrant based upon all the factors of the reason for the inspection and the intended scope of the inspection. All right, so you decided to consent to an inspection or you've got a warrant. The next step is that you're going to need to accompany the inspector. My general recommendations are your fingers are in the belt loops of that inspector. You go where that inspector goes. These inspections happen very quickly, and then once OSHA is done performing their inspection, they will go back to their office. Other managers will look at the documentation they've pulled together and the pictures. They may decide additional citations may be merited based upon just pictures and verbal or written discussion. And it may be up to 6 months before you end up receiving a citation. And it's very difficult to decide what to do once you've got a citation if you have not been with the inspector at all times during the inspection and documented so that you remember what happened and remember the details. The other thing, the only exception to that rule about the belt loops is OSHA does have the right to interview employees privately. And I said employees, so employees can include supervisors, but supervisors are going to be considered to be part of management, and therefore management may have other management representatives present during a supervisory interview by OSHA, or you can have your legal counsel present during those interviews. So only non-supervisory personnel will be privately interviewed. Now, many times employees will say, well, do I have to talk to OSHA? And we find this a lot in ag industry, especially with immigrant employees who don't trust the government and don't want to talk to OSHA. And so what can you tell them? And this becomes a very challenging dialogue, because if you say you don't have to talk to OSHA, OSHA is going to assume you're trying to keep them from talking to the employee, and that can create some dynamics in inspections that can be challenging. You can inform employees about their rights. They have a right to take part in the interview, refuse to be interviewed, or can have a representative with them during the interview. You may want to put that in writing, and if they're Spanish speaking, you may want to put that in Spanish so that there's no question as to what you told them or didn't tell them. And you could even say to OSHA, this is what I told them. I said they can talk to you if they want. They don't have to be interviewed if they don't want to. And they can have a representative with them during the interview if they wish. And I did not obstruct them in any other way. Don't fear the inspector. They're your guests at the facility, and they shouldn't be subjecting you to fear or intimidation, or vice versa. But I've had times when some inspectors will manager, you know, if you don't allow me to talk to these employees, I'm going to have you thrown in jail. They don't have that authority. All they can do is subpoena the employee to their office to question that employee if they wish to do so. And most of the time they will not exercise that right unless there's been an accident or something where they definitely need those facts. But just from the standpoint of just trying to fish for information in a general inspection, they will not usually subpoena employees to decide that they don't want to talk to them. Very important to have a camera with you during the inspection. OSHA will take pictures. That's what their protocols require of them, is to photograph, and in fact, they come back without pictures, their boss is going to send them back, because the bosses want to look at the pictures, decide what violations they see in the pictures, and the pictures become the key evidence in issuing a citation. So you want a picture of everything that they take a picture of. I used to tell employers, well, you know, you may want to take a picture, but I've had a lot of times where compliance officers screw up, you know, this was back in the old days of film, and they'd screw up the development of the film, and they didn't have any pictures, and then they knew you took pictures, so they'd ask for those. Nowadays, that, you know, they're digital photographs, and they are going to have pictures. You need pictures. All right, so have a camera with you, take pictures. Those pictures become very valuable in preparing for a response to citations. And in fact, if I've got pictures of what OSHA took photographs of, many times I can look and see from that what I think OSHA is trying to focus on for purposes of citations. And sometimes I'm able to get ahead of OSHA and then communicate that what they think they saw, or what they think is a violation, is actually explainable by some other detail they don't know about, and actually avoid a citation from being issued through dialogue with OSHA ahead of time. So those pictures become important to me in counseling a client on how to respond to OSHA. Make notes of all comments and observations, what questions were asked, what comments were made, who did the inspector speak to, what measurements were taken, what the inspector said the measurements were. There's lots of standards that talk about heights and distances. Take photos of all the measurements as they're being taken. Take notes on job site condition, good or bad. Even if OSHA doesn't point it out to you, if it's going to be in the photograph, as I said, their boss may later, looking at a picture, decide to fine you for that. And what did they ask to see? They cannot require you to demonstrate anything for their viewing. Now, I would relax that policy if there had been an accident and OSHA wants to see how something happened in order to do a little bit of diagnosis on what happened in the accident. So sometimes I'll relax it if there's an injury or incident. But generally speaking, if OSHA comes along and is asking you to, you know, create a demonstration of something you wouldn't otherwise be operating, you don't have to do that. They don't have control of your employees at your facility. You do not have to pay employees while they're being interviewed by OSHA. OSHA does have a right to private interviews, but again, as I said, employees don't have to be paid for that. So sometimes the dialogue goes like this. You can inspect and you can talk to the employees. We'll let you talk to the employees. We'll let them go on break to talk with you. But just understand that we usually give a 15-minute break. We will pay these folks during their break. But if this is going to expand into much longer than 15 minutes, we may need to have them punch out. So we'd like to try to keep this burden on them in terms of the cost to them of being off of work to a minimum. And that usually works to limit the inspector's time questioning employees. If they ask you to remove employees from an unsafe condition, for goodness sake, definitely do that. Don't argue about whether it's safe or not. You can deal with that later. And they don't have the right to pull something off of a bulletin board, tear a piece of paper off and take it with them. They can ask you for copies of those things. I generally tell clients, have OSHA make you a list of documents that they want. Don't have them having you run around making copies while they're trying to do the inspection, because you'll get distracted and then you violate the rule of fingers in the belt loops. After the inspection, the compliance officer will have a closing conference. Now, in the past, what OSHA had generally done is these closing conferences were often the day of the inspection. But because they're so much more overseen by their managers in their regional offices and area offices, most inspectors are afraid to do the closing conference and commit to what they think until they've talked to the boss. And so these closing conferences often come later. Before the citations are issued, they have to do the closing conference, but sometimes it's the day before they sent the thing in the mail that they do the closing conference. You want to listen very carefully to what they say, take notes as necessary, review all your notes. Are there things that OSHA misunderstands that we can quickly respond to OSHA to fill in the gaps so that you may avoid a citation that they're planning to issue? Because once it's issued, it's hard to unring that bell. And so you want to get as much information from the closing conference, ask as many questions as you can during it. Make sure you've taken photographs, make detailed drawings and explain those dimensions. Make sure the designated representative gets a completed OSHA inspection report along with drawings. And when I talk about an inspection report, and this is something that's available on the Farm Credit East website as well, it's a form that would look something like this. And the version that we've provided to Farm Credit East, you can download. It's a Word document. You can edit it for your particular farm operation. But this gives you a way during an inspection to document it, because you just don't know what to write down. A lot of times I find that the authorized representatives, you're talking, you're interacting, you're looking and observing, you're trying to take photographs, and then it's hard to write notes because there's just too many things going on, and it's hard to think what to write notes about. So if you have some prompts where you can fill in the blanks, it will give you an opportunity to figure out what questions you should be asking yourself for purposes of that documentation. And so there's a series of questions: what are photographs, who they talk to, and many of the things I've already talked about. You'll add additional sheets of paper for drawings, and then you reflect photographs. Photograph number 1 was, they asked this question about that, so you can sometimes refer to the photograph by number or when you took it, and then refer to what the discussion was during that photograph taking. Okay, so that's OSHA. Now, in various states, there also is an effort and so OSHA is a federal agency, and some states are allowed to implement their own OSHA, and they generally follow the same standards that the federal OSHA follows. It's just a state agency that has been granted authority and actually being funded by federal OSHA to run the state program. But most of what I said previously about OSHA inspections applies to the state as well as the federal OSHA agencies. They're very similar. But then there are also states where the federal government may have regulatory oversight, but then the states are also doing things like housing inspections or wage and hour inspections. And I'll give you an example of the statutory enabling statutes for state agencies that you're dealing with. So, for example, in the state of New York, the Commissioner of Labor has some powers of investigation, which say things like the authorized representatives have the power to investigate the wages of persons employed on a farm, to enter the place of business or employment of any employer for the purposes of examining and inspecting any and all books, registers, payrolls, other records, in any way relate to or have a bearing upon wages paid to or the hours worked by any employee, ascertaining whether the provisions of this article and the regulations, et cetera, et cetera. So it's a fairly broad statement of authority. Now, state governments don't have any greater rights than the federal government to inspect a business. You still have a Fourth Amendment right against unreasonable search and seizure without a warrant by a state law enforcement agency as you do with the federal agency. So it's the same. But these statements of the authority of these commissions are fairly broadly written, and many times they don't contain references to except as required by the Fourth Amendment, for example. So don't assume that when the state agent says they have the right to do this, that you don't likewise have a right to a warrant. Additionally, in some of these states, and I've run across this in a number of cases and just handled one in our state Supreme Court on preemption recently, where if the federal government regulates a particular subject matter, such as farm labor housing, the question is whether the state has equal authority to do that or whether they're preempted from doing so. So it's a good idea to consult legal counsel if a state agency is attempting to regulate something that you also have a federal regulatory agency subjecting you to. But in any case, whether you're going to conduct one of those inspections with a state agency, the same type of documentation and the same kind of procedures that I just laid out for an OSHA inspection should be applied to that state agency. And get the information as to why they're there and what they intend to do before you say no. You want to ask the questions of the scope and the purpose and the probable cause, because that will allow you then to have some dialogue with legal counsel, for example, on whether you should continue that inspection or whether you have some rights to demand a warrant, and that may be a triggering mechanism for them to have to go to court and prove that they have legal authority to inspect what they think they have the right to inspect. So always in an inspection process, slow it down, determine what their purpose is, determine what the scope that they intend to engage in. If, for example, in this statutory scheme, the person came in and said, I want records. I want to look at your records regarding your employees' wages and hours. Well, they could do those. That's not necessarily a search in the form of looking at your physical workplace. The Fourth Amendment does apply to the searches of papers as well, but it's a much more relaxed standard. If you have papers that you're required to keep by law anyway, then OSHA or some other state agency or the Federal Department of Labor has the right to demand those through subpoena. They don't have to get a warrant, and a court is generally going to enforce that subpoena because they're records you had to keep anyway. All right, I'll turn it back over to Leah to talk a little bit about immigration.
So I'm going to, I was just saying, I don't know how much this is repetitive, but I'm going to cover ICE, I-9 inspections or audits, and ICE's arrival at a location. Our slides contain more information than what I'll cover today, just to respect everyone's time and allowing sufficient time for questions. There are 3 ICE offices in the area, one in Newark, New Jersey, 2 in New York, 1 in Buffalo, and 1 in New York City. ICE is the investigative and enforcement agency within the Department of Homeland Security. And there's really 2 reasons that are worth discussing today why ICE may be on the property. And that is to either conduct a Form I-9 audit or present a warrant or a subpoena to access the facilities for a specific reason. Again, as Chuck has already covered, employers can insist that ICE present a subpoena or a warrant before entry, but thinking through that process, the scope is critical. If ICE is there to do an I-9, a Form I-9 audit, typically the process goes such as ICE delivers a letter asking to review the farm's I-9 forms and payroll information, and it's within a 3-day time frame. I'm aware of some times where ICE has appeared at a large dairy operation. In this case, it was not in the Northeast, but they gave, 6 weeks advance notice, and it was a mutually agreeable location, hours away that was convenient for the investigator. That's not common. It's much more common to have a 3-day notice time frame. The critical thing is that after a farm receives that notice, they work to prepare the records that are requested, and only those records. Not providing additional information is key. And then, contacting, so that's what you'd prepare the records if you get advance notice. When ICE arrives, you want to make sure that the designated farm representative is there to manage the exchange. And again, Chuck's guidance about talking to the receptionist or the person that first would greet a third party, it's key to have them trained to direct inquiries to the appropriate person. Again, verifying the identity of the agent and the agencies involved in the scope are key. So I-9s would be provided within 3 days. Copies are presented by employees of the I-9 documents are presented by employees to evidence their identity, and U.S. work authorizations are made based upon those records, and those copies must be kept with the I-9 forms and turned over to ICE with the I-9s. We advise, and I will give this caveat, we have a team of immigration attorneys and labor and employment attorneys that do this specifically. Chuck and I do not. But they advise clients to consider a policy of keeping I-9 forms separate from personnel records to ensure that the I-9 forms can be presented without having to sort through other records. You do not want to provide any governmental authority, including ICE, with additional information that's not requested. That just increases the likelihood that they're going to find something to come back and follow up with you on. An I-9 audit does not allow ICE to enter the premises or to search any parts of the premises. So that's a key distinction. If ICE arrives with a warrant or subpoena, the designated farm representative should do their due diligence, examine the scope, determine what the subpoena is about, and contact the management and a legal person if that's appropriate. Agents may only search places and seize items or documents that are covered by the warrant or subpoena. Again, this is the Fourth Amendment. The warrant covers reasonable location search and is limited. The designated representative should follow that person by the belt loop while they're on the premises and document, meaning copy, if that's possible, any and all documents seized by ICE that are covered by a subpoena or a warrant. Members of the press or third parties should not be given access to this information, so there's some sensitivity with the the provision of documents and access. Similar to the OSHA context, employees are not required to answer agents' questions, and the best practices should not volunteer information to agents. This is best accomplished with advanced training and working with the employees and in the HR department to make sure that employees understand their rights and feel comfortable exercising those rights. I'm aware of some companies or some advocacy organizations that have a written document that makes it easy for employees to reference, and that's relatively common. Of course, courteous demeanor and not physically impeding the search or destroying evidence is always a good practice. One significant caveat to the warrant list, needing a warrant for a search, is that under federal law, a search warrant typically needs to be obtained prior to conducting a search, except if the location is within a reasonable distance to an international border. And I left the citations out of the slide because I don't think anybody probably cares, but there's a number of statutory steps to get to that bottom bullet. But a reasonable distance from the border has been deemed to be 100 air miles from an external border of the United States. And it's unfortunate that some of the operations, agricultural operations, fall within, in New York State specifically I'm thinking, but certainly in other Northeast states, fall within that 100-mile area. In those cases, there still needs to be, there's still a reasonableness, but they don't need a warrant. This is just what I'm going to call a wrap-up slide to really think through some best practices for Form I-9 audits and ICE records. We, and specifically our immigration attorneys, recommend an internal audit of Form I-9 records by somebody that knows what they're doing. So both having an internal audit of the Form I-9 records with somebody that keeps those records, as well as relying on, it's a good practice. If somebody is informed internally and they do it one way all the time, they may not identify mistakes that they're making because that's what they think they're doing it correctly. And so we also recommend having an external audit, and sometimes as often as annually, to go through the records and just verify practices and procedures that are in place. That, if it's done with an attorney, is under attorney-client privilege and allows the farm or the operation to make changes to their protocol, document those changes, and put themselves in a better position the next time an auditor arrives at their door. Again, under attorney-client privilege. And then thinking through your record-keeping policy, keeping personnel records and others in a different place than your I-9 records is key. And also having a consistent approach to employment verification procedures. We do have some summary slides at the end of this presentation, but it's all things that Chuck and I have already discussed. And so I'm just going to advance to the end, and I think it might be, certainly we can cover some additional details in the questions if there's anything that people here, the people on the call, on the webinar, want to specifically ask us about. But I know we want to leave room for questions, and so I think it's a good time to break and see what kind of questions we may be prompted.
Great. Thanks, Leah. Thanks, Chuck. Great presentation. Obviously, a lot of information there. And I'll just remind participants that on the chat menu on the side of your screen, if there are any questions you have, you can type those in, and we will try to get those to Chuck and Leah. So while we're accumulating the question queue, wanted to touch base on a couple of things that previously in the presentation. Chuck, going back to the OSHA jurisdiction question, you said it's a fairly new thing in terms of them, getting involved in these types of inspections. You mentioned the threshold. I mean, do you ever follow the strategy of claiming that they don't have authority? I mean, obviously you wouldn't do that. You would do that in conjunction with advice from counsel. But I'm just wondering, in terms of, especially if you're a smaller operation that may not otherwise be subject to OSHA rules. What are your comments on that?
Yeah, initially when this started, OSHA did take the position that housing was temporary worker housing, and therefore they had a temporary labor camp, which was one of the indicia of authority of OSHA. And we began to challenge that housing, at least as it related to dairy farms, was temporary because it's 24/7, 365 days a year. And OSHA eventually backed down on that. And now, at least in Wisconsin, and I believe they're doing this in New York as well, they are not taking the position that the housing itself brings you within their jurisdiction. So if you're less than 10 employees, they do not have jurisdiction. But if you don't point that out, sometimes they miss it. And so you definitely want to have that conversation because they have generally understood now that if it's less than 10 employees, that they do not have jurisdiction to inspect. So don't forget to mention that if you are a smaller employer. And I definitely would tell an employer, raise that issue of jurisdiction at the very outset, because and we've stopped inspections as a result of that.
Okay, great. So we'll get some questions in. One more relative to kind of the consent, and you've laid out how, say sometimes you provide consent by virtue of having a permit to operate. And in other cases, you mentioned specifically on OSHA and ICE, sort of the trade-off between providing consent or requiring them to get a warrant. I was just wondering, in terms of, say, environmental and the EPA, do they have sort of a pre-existing consent, or is really the same calculation there in terms of them arriving to inspect something relative to the facilities in operation, and whether or not you provide consent or request a warrant?
Sure, Tom. I would say it's a little bit fact specific, and so if the facility is regulated under a permit, the facility should review their permit. Again, my example was, I know both New York and Wisconsin permits for, let's say, a CAFO would provide consent in the scope of that permit document, and so that would allow, in New York's case, DEC, the ability to show up to inspect compliance with that permit. So if you are regulated under a permit, you should check your permit and your related permit documents to confirm whether or not you've consented by getting a state or federal permit. Also, EPA has the authority under Section 308 of the Clean Water Act to inspect facilities to verify effluent limitations or violations of that, or to confirm whether or not a facility should be regulated. And also they also have the authority under 308 to require certain documents be submitted to the agency for review. And so depending on why EPA or the state agency is at your doorstep, that would give you some indication as to whether or not they're using their authority under either the permit or Section 308 of the Clean Water Act. Typically, a 308 request often starts with a document request, in which case you can understand the scope, in writing, and then they might follow that up with a site inspection. But not always. Sometimes they show up and rely upon that general authority, and that's where you really need to ask the person showing up why they're there and how they what they're inspecting or evaluating. The other thing is if there is a release. So, for example, if you have had a release and reported that to the appropriate officials, either state or federal, depending on the release, spill reporting obligations vary by state and by what was released and to where. So depending on what happened, if there was a release, oftentimes agency and state officials will rely on a more general clause under state law or federal law to show up and investigate that release, the extent of harm, your remediation of that, etc. So, it's really, I really would step through those three things. Have you agreed to it in your permit? Is there another regulatory or statutory authority that person's relying on? And is there a release or a specific event that's prompting their arrival?
Okay, great. So we had a question come in. What's the recommendation relative to copying I-9 documents? Is it make copies or see the original and note only? So I think the question there relates to, I think, the provision of the documents to the individual doing the inspection.
Yeah. So they are allowed copies of records. I mean, so you would.
Tom, this question may come because a lot of times when you look at a birth certificate, it says you shouldn't copy it.
Oh,
and so
okay.
That discussion you should have that discussion with the agent, as if you collect birth certificates versus a driver's license as the evidence of their saying that they are who they are, and so one of your records is a birth certificate, I would have that conversation with the agent. I wouldn't just go copying it, say, do you want to just look at it? Because I understand birth certificates are not supposed to be copied. I believe that you can copy them if requested by the government agency to do so. Generally, they probably just want to look at them. As far as copying driver's licenses and the I-9 forms, that I would prefer to have less time with this agent than more time. So if you can just send in copies, then you should do so rather than having them sitting on your premises for hours at a time. So I think it's more efficient just to do copies. But I think that question might be prompted by this birth certificate scenario, and the reason is they don't want a lot of copies of birth certificates floating around because people can use those for fraudulent purposes, and so it's prohibited from copying them. But I believe that the government can grant you that authority.
Yeah, the other thing is that oftentimes they will, take the, take the documents, and before they leave with originals, you should certainly copy all of those documents so that you know exactly what was taken and have records of that. Now, depending on the agency, I would not want to have EPA walk out with any originals, or depending on depending on the person. This was in the context of an I-9. We can certainly, if there's some specific questions about a protocol, we can talk to our colleague that handles that for a lot of dairy operations. But yeah, the owner should keep a copy if the agent requires originals.
Okay, thanks. And we've got a bunch more questions here. We only have about 10 minutes left, so I do want to try to get to all of them. So on slide 40, you suggested about keeping the up-to-date and uniform policy on employment verification. I think they want a little bit of an elaboration on that, and wondered if there would be a sample policy that you have.
Sure. I don't, but our colleague might. This was taken from a best practices procedure that our colleague pulled together for a dairy organization, meaning that documenting what the best practices are. So we can certainly see if there is a more detail that we can get on that. I don't have a uniform policy at my fingertips to share, but can certainly follow up on it. The key is that there is a that in order to develop a policy, I would look to see what is required, how does that farm manage those requirements, and what is their process in responding to agency questions or mismatched notice responses. And making sure you're consistently following that same process is very key, because it's one of the slides towards the end was kind of a housekeeping slide. If an agency or I see that you do not have a consistent protocol, that raises red flags for them. And so having a uniform policy that you can show that you follow is really helpful when they say, well, why don't you keep your personnel records in this location, or why don't you re-verify expired identification documents? And you can say, it's our policy not to do that. I've documented that in my policy that I have here, and that's how we proceed. And then you make sure your records match that. So that's probably a more general answer than what the person wanted, but we can certainly follow up if there's some specifics.
Okay, great. A couple of sort of specific ones here. Chuck, going back to the OSHA threshold question, threshold of 10 employees, is that 10 full-time employees or 10 including part-time?
Yeah, there's a measurement
or I should say seasonal as well.
Yeah, there's a measurement on that uses an hours calculation, and I don't recall it off the top of my head, but it is not just, you don't exclude part-time employees, but I wrote a paper on that for NEDPA that was out for Northeast Dairy Producers Association. I could provide that, but I don't have it off the top of my head at this moment.
Well, your recollection is it's something along a full-time equivalent kind of thing.
Yeah, they're going to look at the prior year, and it's along the lines of a full-time equivalent, correct.
Okay. A question asked that this operation does not ask for birth certificates, but should they?
Yeah, well, that's a great question for our colleague. There's appropriate documentation that's allowed on the Form I-9, and you just need to make sure that you meet those documentation requirements. I believe a birth certificate is one of them, but it is not necessary.
Yeah. Okay. Also, going back to, we had a follow-up question from our question on the making copies issue. I think we didn't quite get what they were getting at. I think what they were saying is that some people are being advised that they're not, that as the employer, you're not supposed to make copies of the employee's ID. So then I guess the question is, then how do you have the proof of what was used to verify identity? So I think that was the question. What's your take on that?
Yeah, that is different than how I answered it. I would go to the Form I-9, and honestly, what I would suggest, just to help with making this as clear as possible, I would, if this person could just give us their contact information, I will follow up with our colleague that does I-9 work all day.
And we'll send that to you too, Tom.
Yeah.
Yeah, and I know this individual, so I will make that connection. Great. So is the advice regarding the engagement with inspectors that you've outlined, is that applicable to worker protection inspections as well, and would there be any differences?
Yeah. So the Constitution, so we deliberately started the discussion with the Fourth Amendment. The Fourth Amendment of the Constitution that sort of forms the basis for a lot of our discussion only applies to government. It does not apply to non-government individuals. So advocates for an individual, they also don't have the statutory authority that the government entities have, but they're not subject to the Fourth Amendment of the Constitution. So when you get into advocacy, non-government type of individuals, then you start to get into things like, do they have the right to come onto the premises and go into the housing of the individual's workers? And the answer depends on if they are invited. And it also depends, and then that comes down to state law. Is that housing a landlord-tenant relationship, or is that the premises owned or controlled by the farm? That's a state-by-state question. But certainly an advocacy group would not have the right to come into the operational facilities or to trespass on land that is not leased or rented to an employee, even with an employee's consent. So you're right against trespass. Again, that's a state law governed concept. As an owner is going to apply, but it may have to be relaxed with respect to housing, where an individual is invited into that housing by one who is renting that housing, because they, just like a tenant in an apartment, I have the right to associate and have people come in. Okay.
Let's see. Just a couple more here, and we'll be wrapping up. So, in referencing a specific New York example in terms of a CAFO permit, in terms of that the permit itself allows a DEC inspection. What about non-CAFO or other types of permits in terms of that having a requirement to let the DEC onto the farm?
I think I understand the question. Is if you're not a CAFO, is there other reasons why DEC can access the property? I would go to the other two, right? Things that I identified, and that is that are you reporting a spill, and is there another environmental matter? So was there a pesticide application, and there was an allegation of an overspray? Does DEC might arrive and want to question or look at records or that sort of thing, in which case that would be likely under a permit, frankly. So you should look at that, ask the question as to why they're there, and if there's a spill or an immediate environmental need, they would likely rely on a general state statute to allow them to, investigate environmental health and safety. That doesn't mean that you necessarily need to consent, right? And so that is where we started the conversation, is you can choose to consent to that, but if they want access, they can't give you a reason why they need access, and they can't, tell you how you've already consented in a permit document. You can ask questions until you feel comfortable with either allowing them onto your property, or tell them that you need more information, and consider requesting that they get a warrant. Getting a warrant would require that agency to go to a court and get a warrant. Oftentimes, if there's a reasonable need, those warrants are issued, and sometimes the inspector comes back, the next day in maybe less of an agreeable manner. So that's the kind of weighing of the matter, but it really is fact specific. So you'd have to, if there was not a spill at place or a spill at issue, and they can't describe to you why they need access to your site, you should certainly continue to ask questions until you're either comfortable with it, or ask them to come back at a later time or require a warrant.
Okay. Well,
and there's other permits. I was just going to say that, I gave the example of a CAFL permit. There's other, there's other permits that might come into play. So if you have a above ground storage tank and it's registered with the state, they might, doing a regulatory compliance check. There's other permits that might have a compliance inspection part to that. I guess I would just note.
Yeah. So I'm going one last question here before we wrap up. So we had a question about the validity of a request. The individual asked about a fax request purporting to be OSHA, and how do you determine whether that's legitimate or not, someone phishing or trying to stir up trouble there? What would your advice be on that?
Yeah, so at least with respect to OSHA, if they fax you a notice, they will usually call first and then send the fax. So there should be a twofold communication, phone call and fax. And you could call that phone number at the top. It should say OSHA. It will have the area office. It will be signed by somebody purporting to be the area director or somebody. It will always have the area director's name and then maybe somebody signing on their behalf. Call that phone number. If you didn't get a call along with that notice, then you're right away suspicious. Call that number and verify that they in fact did send it to you. If they come physically on site, they are supposed to have a credential, a badge, along with a business card. Sometimes they'll just give you the business card. You can ask to see their badge. Many of the younger ones are very proud of their badge. So there have been sales agencies that try to sell you goods and equipment and services purporting to be the Occupational Safety and Health Corporation or something like that. It is illegal to pose yourself as a federal agent, and there is jail time and fines for that. So, get as much information as you can. Get the name, get a phone number, anything you can get from them so you can follow up and perhaps prosecute if they're fake.
Okay, great. Well, we've reached the end of our time. Leah, Chuck, I want to thank you so much for the presentation and the great information you provided. Just want to remind everyone that the slides in the recording of the webinar will be posted at farmcrediteast.com/webinar, and we appreciate everyone's attendance today. Thanks, and have a great weekend.
Thank you.
Thank you.